Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. All right, so today on the podcast, we have a very extra special treat because we have a guest reader today, which is super exciting. We have Ali Tejani, who was our colleague at Windsor in our year, and he is going to read for us Jonsson and Lymer, which is a civil case out of Alberta that deals with vexatious litigants.
Which is really interesting because I know I haven't read the case yet, and I want to, but time's of the essence these days. But I like the discussion of vexatious litigants because I think it's something we're not taught about in law school, or at least I never was. You hear the term, you understand the term, but you never actually are able to encapsulate or actually know what it means in reality. Because I know what a vexatious litigant is. It's, somebody who's bringing a lawsuit without any merit or any evidence to it, just to bring the lawsuit to hurt somebody.
Yes. No, I mean, I know about it in the context of it was on my civil procedure final exam. And I didn't really know too much about it either. I'm very glad that Ali brought this case to our attention because honestly, I'd never heard about it, which I must say is poor form on both our parts since Windsor has such a storied history of helping National Self-Represented Litigants Foundation with Professor McFarland. The school does a lot for self-represented litigants, which is excellent. But I must say, in my great shame, I had never heard of this case until Ali drew it to my attention. He wanted to let us know that he thinks the case is important due to the stance on vexatious litigants and how, historically labeling someone as a vexatious litigant has tended to deny self-reps access to justice. And this case is saying that, you can't just do that. It has to be sort of extraordinary circumstances when you're going to label someone as being vexatious.
Yeah, absolutely. Because when you label someone as vexatious, the implications that flow from that are very serious and very severe. And it's almost unfortunate that this decision had to be made, but considering the fact that self-represented litigants don't necessarily have the legal information, the legal knowledge, the know-how, or even the money to hire somebody to help them with it, and then they get slapped with a vexatious litigant label effectively, hurts them in the long term because how can they find justice for whatever they're seeking, right? To hold them to the exact same standard as a fully trained legal professional, I don't know. It seems strange to slap somebody who doesn't have that requisite knowledge and saying you ought to have known with that label.
Definitely. And I think that's sort of what the court is saying here, that, these orders, vexatious litigant orders, can be insurmountable for self-represented litigants. And then all of a sudden their access to the court is essentially denied, which is, self-evidently, that's an access to justice issue. And, I forgot to mention that the National Self-Represented Litigant Project was actually an intervener on this case, which is, I think, how it first came to Ali's attention. But yeah, it's weird, because I think especially as people who are legally trained now, which is scary to say that our legal training has formally ended in law school, you can be frustrated. Self-reps can be frustrating, but, the court system's not for us. The court system is for them. It's for the public. It's not for lawyers. The court system doesn't exist for lawyers. And, I always think it's a good idea to sort of take a step back and realize that, while this may be frustrating, not everyone is lucky enough to be the benefit of the same training that we've been the benefit of. And so, they're looking at it from a place of what is this and how do I navigate it, which can be very frustrating.
Yeah, absolutely. And I think that's one of the good things that we kind of got from both of our experience at CLA is
Definitely.
You learn to step back and put yourself in your client's shoes in terms of understanding what they understand, to understand they're approaching a process that has, one, never been open to them, and two, is foreign is the easiest way to explain it, right? It's so different compared to the rest of our lives, and we're so ingrained in it. It's like second nature to us now.
Yep.
And it'll only become easier, but going back and remembering that, hey, these people have never even set foot inside a courtroom or even don't even know where the courthouse is.
Yeah, it really is like a language, right? It's a language that you've been taught to speak through intensive training. And so it's best to try to be not judgmental when looking at people who've never had the opportunity to learn that language, right?
Definitely.
But yeah, so anyway, we'll let Ali take it away. We love Ali to absolute pieces. He is one of our absolute favorite people, and we hope you enjoy his reading of Jonsson and Lymer.
Jonsson and Lymer, 2020 Alberta Court of Appeal 167. Reasons for judgment. The appellant appeals a vexatious litigant order made against him, and a sanction imposed on him for contempt. The appeal was argued with two other appeals raising related issues, Macus and Alberta Health Services, and Vong Van Thai Holdings and Alberta Minister of Justice and Solicitor General. The three appeals raise issues about the scope of the court's inherent jurisdiction to restrain vexatious litigation, the proper breadth of vexatious litigant orders, and related procedural issues. In the circumstances, some broader discussion of vexatious litigant orders is required. Facts. The appellant was involved in an investment scheme under which he solicited funds from a number of investors in breach of the Alberta Securities Act. He is an undischarged bankrupt and has been involved in a lengthy dispute with some of the investors who are trying to trace their lost funds. Reasons at paras 1 through 3. The appellant was ordered to disclose documents, and when he failed to do so, he was found in contempt. He failed to fully purge his contempt. The investors then brought the present application seeking the imposition of sanctions on the appellant for his contempt, including an order under the Judicature Act declaring the appellant to be a vexatious litigant. Even though the application for a vexatious litigant order was specifically brought under the Judicature Act, the case management judge did not analyze it on that basis, ruling at paragraph 32, quote, "This court no longer uses that procedure, but instead evaluates the potential need for court access restrictions on a prospective rather than punitive basis, under its inherent jurisdiction to control its own processes," unquote. In adopting that approach, the case management judge followed a line of Queen's Bench decisions which described the procedure under the Judicature Act as, quote, "obsolete, or at best duplicative, of the authority vested in the Alberta Queen's Bench as a consequence of its inherent jurisdiction to control its proceedings," unquote, and which apply a common law, quote, "more robust, functional, and efficient response to control of problematic litigants," unquote. Templanza and Ford at paragraphs 99-103. The case management judge found many indicia of vexatious activity, including some that do not appear to be within the parameters of the Judicature Act. He granted a vexatious litigant order significantly wider than the one applied for. Compare the reasons at paragraph 58 to the order granted at paragraph 138. The case management judge next considered the appropriate sanction to impose on the appellant for his contempt of prior court orders. He concluded that, despite the appellant's assertions to the contrary, he had still not purged his contempt. He had not done everything as could reasonably be expected to disclose the documents he was ordered to produce. The case management judge found the appellant's contempt to be persistent and intentional, and that a number of aggravating factors were present. Reasons at paragraph 182. This was one of the exceptional cases where incarceration was required to meet the objectives of deterrence and denunciation, and the case management judge imposed a sentence of 30 days. The appellant was given 90 days thereafter to purge his contempt, failing which the case management judge would determine what further steps should occur. The appellant was granted permission to appeal on the following issues. A. Did the case management judge err in finding that the appellant was a vexatious litigant? B. Did the case management judge err in failing to ensure a full and fair hearing in respect of the vexatious litigant motion in breach of natural justice? C. Did the case management judge err in imposing an overly broad vexatious litigant order? D. Did the case management judge err in imposing as a sanction for contempt a period of incarceration without conducting a full and fair viva voce hearing, and in breach of the requirements of Section 7 of the Charter and the principles of natural justice? The National Self-Represented Litigants Project was given permission to intervene to focus on the broader policy implications of vexatious litigant procedures. It tendered as fresh evidence a report by Dr. J. McFarlane, the National Self-Represented Litigants Project, Identifying and Meeting the Needs of Self-Represented Litigants, dated May 2013. This report noted the increasing presence of self-represented litigants in the legal system, and that the vast majority of vexatious litigants are self-represented litigants. The report suggests self-represented litigants, quote, find the courts complex, confusing, and intimidating, and often lack the knowledge, skills, and literacy or language fluency to participate effectively in their own litigation, unquote. The very behaviors that vex courts and other parties are often generated by those challenges. Many of the proposed indicia of vexatiousness, such as advancing hopeless causes and engaging in inappropriate courtroom behavior, quote, are also the behaviors exhibited by ill-informed or emotionally overwhelmed self-represented litigants, unquote. Vexatious litigant orders are said to be justified on the basis that they do not bar access to the courts. But many of the conditions in vexatious litigant orders may amount to insurmountable barriers. 90% of self-represented litigants represent themselves because they cannot afford counsel. A precondition that the self-represented litigant retain counsel or pay costs may amount to an insurmountable barrier. Self-represented litigants returning to court are tainted by the finding of vexatiousness, often made, quote, in lengthy, colorful, and inherently prejudicial reasons, unquote. While no other party objected to the introduction of the report, it was not tested by cross-examination, and the author was not qualified as an expert witness. The opinions expressed would not be universally accepted by all involved in the judicial system, and some may be inconsistent with judicial experience. While some of these observations may generally be accurate, it obviously does not follow that they excuse vexatious behavior. Vexatious litigant orders in context. A vexatious litigant order prevents a named litigant from commencing or continuing proceedings in court, unless the litigant obtains permission from the court to initiate the intended step or proceeding. It is important to remember the constitutional context. The rule of law, which is one of the foundational concepts of the Constitution, has many facets. One is that no person is above the law. All citizens are to be subject to the same law, regardless of social status, wealth, or high office. Requiring every citizen to obey the law is an empty concept unless there is some way of holding everyone to account. The rule of law thus requires the establishment of a universal superior court of general jurisdiction, to which all citizens are subject. Universal access to the courts is therefore an important component of the rule of law, allowing every citizen to hold every other citizen to account. It follows that any restriction or impediment to court access must be carefully monitored. The point was made in Trial Lawyers Association of British Columbia and British Columbia Attorney General. The historic task of the superior courts is to resolve disputes between individuals and decide questions of private and public law. Measures that prevent people from coming to the courts to have those issues resolved are at odds with this basic judicial function. The resolution of these disputes and resulting determination of issues of private and public law, viewed in the institutional context of the Canadian justice system, are central to what the superior courts do. Indeed, it is their very book of business. To prevent this business being done strikes at the core of the jurisdiction of the superior courts, protected by Section 96 of the Constitution Act. While this suffices to resolve the fundamental issue of principle in this appeal, the connection between Section 96 and access to justice is further supported by considerations relating to the rule of law. This court affirmed that access to the courts is essential to the rule of law in BCGEU and British Columbia Attorney General. As Dixon C.J. put it, quote, there cannot be a rule of law without access. Otherwise, the rule of law is replaced by a rule of men and women who decide who shall and who shall not have access to justice, unquote. In the context of litigation, which effectively denies people the right to take their cases to court, concerns about the maintenance of the rule of law are not abstract or theoretical. If people cannot challenge government actions in court, individuals cannot hold the state to account. the government will be, or be seen to be, above the law. If people cannot bring legitimate issues to court, the creation and maintenance of positive laws will be hampered, as laws will not be given effect. Of course, a vexatious litigant order does not bar all access to the courts. It is merely a screening mechanism, and vexatious litigant orders invariably provide that the person subject to the order can commence or continue proceedings with leave of the court. See Judicature Act, Section 23.1 sub 7. Nevertheless, a vexatious litigant order is a barrier to access to the courts, and depending on the terms of the order, it may become an insurmountable barrier. There are many procedural techniques for ensuring that litigation is conducted in a proportionate manner. A. Courts have a wide discretion to grant procedural orders. Procedural orders may impose terms, conditions, or time limits on proceedings, may regulate the sequence in which proceedings will occur, may set the method by which issues should be resolved, and may otherwise manage the litigation. B. Case management orders are made in and directed at a specific existing action, in which a single judge is nominated to deal with every interlocutory issue. They can be contrasted with vexatious litigant orders, which generally relate to anticipated future applications or actions. Case management is appropriate for complex actions, actions involving multiple parties, or actions where the litigants have been unable to establish a good and respectful working relationship. A case management judge has wide powers. C. Courts can impose sanctions for failure to comply with the court orders or the rules of court. For example, striking pleadings, cost awards, penalties, and sanctions for contempt. Vexatious litigant orders are not an effective or remedial sanction for such failures. Vexatious litigant orders are the most extreme response to inappropriate litigation. Vexatious litigant orders are intended to be extraordinary in nature, and they should only be used when other procedural techniques are ineffective. They are not generally an appropriate method of specific case management. They should be no wider than is necessary in the circumstances. Vexatious litigation must be contrasted with unmeritorious or unsuccessful litigation. Where litigation is without merit, it should be struck out under Rule 3.68, or summarily dismissed under Rule 7.3, upon application of the appropriate tests. A vexatious litigant order is not the appropriate response to litigation that is merely lacking in merit, absent a pattern of abuse. Vexatious litigants must be distinguished from self-represented litigants. Merely because a self-represented litigant uses a process that is not in accordance with the rules of court, or advances a claim without merit, does not mean that they are vexatious. Many self-represented litigants are unfamiliar with court procedures, and are inadequately or inaccurately informed about their legal rights and the limitations on them. Merely because the self-represented litigant excessively or passionately believes in the merits of his or her case does not make them vexatious. On the other hand, being self-represented does not excuse abusive court procedures. Rule 1.1 sub 2 confirms that the rules govern all persons who come before the court, quote, whether the person is a self-represented litigant or is represented by a lawyer, unquote. The Canadian Judicial Council's Statement of Principles on Self-Represented Litigants and Accused Persons, 2006, confirms that principle. While the Statement of Principles reminds courts of their obligation to assist self-represented litigants, it also confirms, quote, self-represented persons, like all other litigants, are subject to the provisions whereby courts maintain control of their proceedings and procedures. In the same manner as with other litigants, self-represented persons may be treated as vexatious or abusive litigants where the administration of justice requires it. The ability of judges to promote access may be affected by the actions of self-represented litigants themselves, unquote. This point was confirmed in Trial Lawyers Association at paragraph 47. Quote, there is no constitutional right to bring frivolous or vexatious cases, and measures that deter such cases may actually increase efficiency and overall access to justice, unquote. A litigant cannot therefore shield or excuse abusive behavior simply because he or she is self-represented. Ultimately, the response to problematic litigation must find the proper balance between maintaining reasonable access to the court while preserving court resources and shielding other litigants from abusive behavior. Controls must be implemented through fair and proportionate procedures. Jurisdiction to make vexatious litigant orders. As noted, in Alberta there are two competing sources of jurisdiction to make vexatious litigant orders. The statutory authority is found in Section 23 of the Judicature Act. In addition, the Court of Queen's Bench has sometimes relied on an inherent common law jurisdiction to make such orders. The inherent jurisdiction has been said by judges of that court to supersede the statutory regime, not merely to operate parallel to it. In England, it has long been accepted that the court has an inherent jurisdiction to control applications in an existing proceeding, notwithstanding any parallel statutory jurisdiction. Such orders are a logical extension of case management orders. The inherent jurisdiction to regulate new proceedings in England was not confirmed until the decision in Ebert and Enville, 2000. A parallel inherent jurisdiction has been recognized in case law. Prior to 2007, an application in Alberta for a vexatious litigant order could only be brought with the written consent of the Minister of Justice and Attorney General of Alberta. That requirement reflected that there is a public and constitutional aspect to denying access to the courts. The statute required that the underlying vexatious conduct of the litigant be, quote, habitual and persistent and without any reasonable ground, unquote. In 2007, the Judicature Act was amended to remove the requirement for consent, requiring instead that the application be on notice to the Minister of Justice and Attorney General. The amendments introduced an expanded definition of what constitutes vexatious behavior. Quote, for the purposes of this part, instituting vexatious proceedings or conducting a proceeding in a vexatious manner includes, without limitation, any one or more of the following. A. Persistently bringing proceedings to determine an issue that has already been determined by a court of competent jurisdiction. B. Persistently bringing proceedings that cannot succeed or that have no reasonable expectation of providing relief. C. Persistently bringing proceedings for improper purposes. D. Persistently using previously raised grounds and issues in subsequent proceedings inappropriately. E. Persistently failing to pay the costs of unsuccessful proceedings on the part of the person who commenced those proceedings. F. Persistently taking unsuccessful appeals from judicial decisions. G. Persistently engaging in inappropriate courtroom behavior, unquote. This provision confirms that it is persistent behavior that is to be addressed by vexatious litigant orders. Further, vexatious litigant orders were to be based on the past conduct of the litigant. Where the persistent past conduct of the litigant supported an inference that additional vexatious proceedings might be brought in the future, a vexatious litigant order might be appropriate. Orders made under the Judicature Act are not punitive, they are protective and prospective. Both the statutory and the inherent approach rely on the inference that past behavior is predictive of future behavior, and they are both intended to be protective and prospective. An argument can be made that the legislature intended to occupy the field of vexatious litigant orders by these provisions. The existence of a comprehensive statutory regime on vexatious litigant orders implies certain boundaries on any residual inherent jurisdiction of the courts. On the other hand, the definition of vexatious conduct in Section 23(2) of the Judicature Act is inclusive, not closed. It is, however, difficult to anticipate all the circumstances that might arise, and the inherent jurisdiction of the superior courts is not easily displaced. Notwithstanding the provisions of the Judicature Act, there is a residual common law jurisdiction to regulate vexatious conduct. As confirmed in Ontario and Criminal Lawyers Association of Ontario 2013, at paragraph 26, quote, the inherent jurisdiction of superior courts provides powers that are essential to the administration of justice and the maintenance of the rule of law and the Constitution. It includes those residual powers required to permit the courts to fulfill the judicial function of administering justice according to law in a regular, orderly, and effective manner, subject to any statutory provisions. Limits on inherent jurisdiction. Accepting that, notwithstanding the provisions of the Judicature Act, a residual common law jurisdiction to regulate vexatious conduct remains, which procedure takes priority? The answer is provided by the context. As noted, the superior courts are a key part of the Canadian constitutional infrastructure. Many characteristics, powers, and attributes of the superior courts are described as being, quote, inherent, unquote. In some respects, these characteristics have little in common other than the use of the common adjective inherent. They can be invoked, quote, in an apparently inexhaustible variety of circumstances, unquote, quoting I.H. Jacob, the inherent jurisdiction of the court. Their many manifestations derive from different constitutional, statutory, and common law sources, and they are governed by different principles and rules. Some of these inherent features are entrenched to a greater or lesser degree in the unwritten constitution. For example, the superior courts have an inherent right to independence protected by the Constitution, security of tenure, financial security, and administrative independence. The principles underlying inherent judicial independence are not engaged by this appeal. The superior courts also have an inherent jurisdiction to judicially review the decisions of administrative tribunals. The core of that jurisdiction is also constitutionally protected. This inherent jurisdiction extends to assisting administrative tribunals in discharging their functions. The legislatures can, however, regulate matters such as the procedures to be used, the standards of review to be applied, and the levels of procedural fairness required. The principles underlying judicial review are not engaged by this appeal, although they are by the companion appeal of Macus and Alberta Health Services. Another inherent power of the courts is the jurisdiction to issue injunctions to restrain breaches of public and private rights. This jurisdiction was originally vested in the Courts of Equity and is now confirmed by Section 5 of the Judicature Act. This inherent power is also most directly engaged by the companion appeal of Macus and Alberta Health Services. This appeal is most directly concerned with the aspect of the inherent power of the courts that gives them the ability to prevent abuses of their own processes. As confirmed in Criminal Lawyers Association at paragraph 26, the inherent power of the court to control its processes is, quote, subject to any statutory provisions, unquote. It is, at its highest, parallel to the statutory regime. Closely related is the power of the courts to make rules of procedure, now confirmed in Rule 1.6. By convention, in Alberta, neither the courts nor the executive branch make rules unless they have been reviewed by the Rules of Court Committee established by Section 28.2 of the Judicature Act. When citing general statements about the inherent characteristics of the superior courts, attention must be paid to the circumstances in which the statement was made. For example, statements that inherent jurisdiction is limited by statute only apply where there are no constitutional limits at play. Broad statements about the inherent characteristics of superior courts may not be completely transferable outside their particular context. The inherent power of the superior courts to prevent abuses of their processes is an aspect of their jurisdiction that is subordinate to related statutory provisions. As stated in Obiter at p. 493, quote, "This is one of the situations where it is accepted that notwithstanding the intervention of Parliament, an inherent jurisdiction remains alongside the statutory jurisdiction. This does not mean that intervention of Parliament may not have cut down the inherent jurisdiction of the court. If there was an application for an order of the same width as the statutory jurisdiction, the courts could only appropriately deal with such an application under the statutory jurisdiction. The inherent power to make an order is now more restricted." Unquote. It is an error for the courts to assert an aspect of this inherent jurisdiction that conflicts with the wording in the Judicature Act, or that takes priority over the statutory regime. For example, applications for vexatious litigant orders must be served on the Attorney General, regardless of which jurisdiction is being invoked. Vexatious litigant proceedings are to be on notice. Anyone charged with vexatious conduct must be given a fair opportunity to respond. The court's ability to initiate such applications on its own motion is not the same thing as granting those orders without notice. Ex parte vexatious litigant orders should be rare, even on an interim basis, not routine, and when justified, must be short-term. As stated in Endine and British Columbia, citing the seminal article by I.H. Jacob, The Inherent Jurisdiction of the Courts, quote, "The courts have recognized that given the broad and loosely defined nature of these inherent powers, they should be exercised sparingly and with caution. It follows that courts should first determine the scope of express grants of statutory powers before dipping into this important but murky pool of residual authority that forms their inherent jurisdiction. And it is only where broad statutory authority is unavailable that inherent jurisdiction needs to be considered as a possible judicial tool to utilize in the circumstances." Unquote. It follows that resort to any residual inherent jurisdiction to control vexatious litigation should only be made when a. the provisions of the Judicature Act are clearly inadequate to answer the problem, and b. there are compelling reasons to step beyond what the statute provides for. Some trial court decisions have expressed the opinion that the applicable provisions of the Judicature Act, quote, "are obsolete," unquote. No authority is given for the court's mandate to marginalize legislation in this manner. The Interpretation Act declares that statutes are always speaking and should be applied to circumstances as they arise. Quote, "The decision to pursue a social goal, eradicate a mischief, or promote a policy lies at the heart of the legislative function. It would exceed the constitutional role of the courts to effectively reverse this decision by refusing to apply legislation to existing facts." R. Sullivan, Sullivan on the Construction of Statutes, unquote. The courts cannot refuse to apply statutes based on a bald declaration of obsolescence. Legislation must be interpreted and applied in its present context, but legislation does not become obsolete unless and until the legislature repeals it. As noted in Crazel Corps and Equitable Trust Co., quote, "This court has recently observed that it cannot do by interpretation what Parliament chose not to do by enactment. But the converse is also true. Courts may not undo by interpretation what Parliament chose to do by enactment. If Section 8 reflects bad or outdated public policy, the remedy lies with Parliament, not with the courts." Unquote. The relevant provisions of the Judicature Act have been amended as recently as 2014, precluding any inference that the legislature has forgotten about them. The vexatious litigant provisions of the Judicature Act may be narrower than some would like, but that does not provide any basis for the courts to displace the statutory scheme with what is perceived by some to be a better solution. The justification sometimes given for stepping around the provisions of the Judicature Act and instead relying on an expansive inherent jurisdiction is that the provisions of the statute are not responsive to the problem. For example, the regime set out by the Judicature Act has been criticized because it requires persistent behavior that, quote, "only targets misconduct that has already occurred," unquote. The asserted inherent jurisdiction of the court is said to be better because it assesses, quote, "the potential need for court access restrictions on a prospective rather than punitive basis," unquote. As noted, the fact that the Judicature Act draws an inference of likely future conduct from past conduct does not make it punitive. The objective is still to prevent future vexatious conduct, not to punish past behavior. Secondly, the statutory requirement that there be a pattern of persistent behavior is reflective of the important constitutional values surrounding access to the courts. One or even a few procedural missteps do not justify the extreme remedy of a vexatious litigant order. Thirdly, the legislature has determined that a pattern of past persistent behavior is a precondition to a vexatious litigant order, and the court cannot use any inherent jurisdiction to ignore it. While some may disagree with the need for persistence, that is the standard that has been selected by the legislature. Persistence is important because the more persistent the behavior, the stronger is the inference that past behavior predicts future behavior. The inherent jurisdiction of the court might still be invoked in exceptional circumstances, absent persistence, but the inherent jurisdiction of the court does not permit the complete abrogation of that requirement. As previously noted, access to the court has a constitutional dimension. Barring access to the court, absent some actual pattern of abuse of that right, is problematic. A single procedural misstep by a litigant calls for a single and focused remedy, not a blanket vexatious litigant order. While the definition of vexatious conduct in Section 23(2) of the Judicature Act confirms that it is without limitation to what might be vexatious, it nevertheless provides some guidance as to the type of conduct that justifies limiting access to the courts. The inherent jurisdiction asserted by the Court of Queen's Bench relies on indicia of vexatiousness, many of which overlap with the statutory definition. See the list of over 20 in Alberta Treasury Branches and Harish. The list includes some characterizations that are themselves very wide. For example, quote, being an OPCA litigant, unquote. However, some generic or imprecise indicia are questionable reasons to impose blanket limits on court access. Hopeless proceedings, collateral attacks, making unsubstantiated allegations of misconduct, and, quote, initiating busybody lawsuits, unquote, are all generic failings that demonstrate a lack of merit or standing. There are specific remedies for those errors: striking out pleadings under Rule 3.68 or summary dismissal under Rule 7.3. Individual occurrences should be dealt with under those focused rules. It is only when this type of conduct is persistent that vexatious litigant orders may be justified. Quote, where the litigation has a political focus directed to the correction of perceived government shortcomings, unquote, is said to be another indicium of vexatiousness. This criterion is particularly problematic because one of the constitutional backbones of universal access to the superior courts is to allow evaluation of the legality of government action. Claims that are justiciable are legitimately brought, even if they turn out to be without merit. There is no recognized barrier to political litigation. There are many reported decisions that might be characterized as political, but they are not vexatious. Examples include a great deal of charter litigation, specifically under Section 7 and Section 35, and cases like Harper and Canada, and Miller and the Prime Minister. In Pintea and Johns, the Supreme Court endorsed the Canadian Judicial Council's Statement of Principles on Self-Represented Litigants and Accused Persons, 2006. As noted, the Statement of Principles does not endorse abuse of court procedures by self-represented litigants, although some of them misunderstand the direction in Pintea that the system should be more accommodating of the self-represented. Nevertheless, it is problematic to suggest that the mere assertion of rights as a self-represented litigant is itself, quote, a separate and independent reason to conclude that court access restrictions are appropriate for this litigant, unquote. The identified indicia are also not limited to conduct within the legal system, but are said to engage external conduct. Reference to litigation conduct in other jurisdictions and other forums is legitimate. But the vexatious litigant analysis must not turn into a broad-based investigation into the character and political views of the litigant, based on speculation about his or her motives and possible future conduct. Attempted medical diagnoses of the litigant are inappropriate. The analysis is not to be a, quote, deep inquiry into the litigant and his or her personal characteristics and activities, unquote, as suggested in the court summary of Unruh and National Dental Examining Board. These indicia invite a formalistic analysis which does not focus on the individual litigant or whether the perceived indicia justify a vexatious litigant order in the particular case. Rather, they result in wide boilerplate orders arising after, quote, an assertion of the court's inherent jurisdiction supported by a string of bare citations, unquote. J. Watson Hamilton, The Increasing Risk of Conflating Self-Represented Litigants and Vexatious Litigants. Different categories of vexatious litigants are identified, inviting an inference of guilt by association for the particular respondent, even if he does not fit any category. An example of the use of vexatious litigant orders to address the merits of the litigation can be found in Unruh. The statement of claim in that action did not disclose any cause of action, or claim any relief that was potentially available. It was properly struck out under Rule 3.68, but was a vexatious litigant order justified? As the court noted, quote, viewed as a whole, while this pleading was clearly an abuse of this court's processes, which warranted the action being struck out per Rule 3.68 and CPN 7, the statement of claim does not provide much assistance in evaluating whether Unruh should be subject to continued court access restrictions. Arguably, his bad action might be a one-off, unquote. As previously noted, a one-off misstep calls for a single focused remedy. The court's own research, however, disclosed that between 2001 and 2006, i.e. 12 years before the statement of claim was issued, Unruh purported to practice dentistry without a license, and resisted attempts to stop him. Even though the practice of dentistry has nothing to do with the prosecution of litigation, this was found to be enough to declare him a vexatious litigant. Without evidentiary support, the Chambers judge presumed he had a, quote, mental health component, unquote, behind his fixed desire to be a dentist, and that supported him being a vexatious litigant. In summary, the inherent jurisdiction of the courts to control their processes is subordinate to the statutory process for vexatious litigant orders found in the Judicature Act. The inherent jurisdiction should be invoked when the statutory process has proven to be inadequate in the particular case, not routinely based on a perception that the inherent jurisdiction approach is preferable. The inherent jurisdiction should not be exercised in a manner that is inconsistent with the principles underlying the statutory regime. It should only be used when more focused remedies are unavailable. It goes without saying that a vexatious litigant order should only be granted where it would serve the underlying purposes of the process. The role of the court in controlling vexatious proceedings. Prior to 2007, a vexatious litigant application could only be brought by way of an application, with the written consent of the Attorney General. The 2007 amendments confirmed that the court could act on its own motion. That provision, however, was not intended to displace the litigant-driven adversarial system. It is important that the judges and the court remain neutral and impartial. Judges should not routinely become protagonists in the litigation. As it was put in R. and Mian, quote, our adversarial system of determining legal disputes is a procedural system involving active and unhindered parties contesting with each other to put forth a case before an independent decision maker. An important component of this system is the principle of party presentation, under which courts rely on the parties to frame the issues for decision and assign to courts the role of neutral arbiter of matters the parties present, unquote. This point has been made many times. For example, in Imperial Oil and Jacques. Quote, although the power of judges to intervene in the conduct of civil proceedings has become increasingly broad, judges generally do not play an active role in the search for truth. In an accusatory and adversarial system, the delicate task of bringing the truth to light falls first and foremost to the parties, unquote. Another example of the principle is found in R. and Oraz. Quote, a cautionary note is in order. It is essential that trial judges not descend into the arena. It is always preferable for the trier of fact and the adjudicator of law to leave to the parties or their counsel the initiative to advance legal and factual arguments. Our system of criminal justice is premised on an adversarial model. Judicial inquests are not part of that process. While judges, in keeping with their sworn duties, may seek clarification of points in issue, the extent to which a judge may properly go beyond that is circumscribed. The judge must not enter the fray. That which governs is the necessity of ensuring a fair trial, and one that is perceived by all to have been conducted fairly and impartially, unquote. Just because the court can initiate vexatious litigant proceedings on its own motion does not mean that it should routinely do so. A primarily court-initiated process risks undermining the neutrality of the court. As noted, the Court of Queen's Bench has adopted a policy of diverting vexatious litigant proceedings. Even when proceedings are brought by litigants under the Judicature Act, the court routinely converts the application to an invocation of the court's inherent jurisdiction. Where a litigant brings an application for relief under the Judicature Act, the application should be dealt with under the statute. If the court seizes the agenda and diverts the application to any process based on a residual inherent jurisdiction, then the judge has entered the fray. This may give the appearance of the judge siding with the applicant. Further, the courts should generally not decide issues or grant relief outside the scope of the pleadings, if only because the respondent is entitled to notice of the case he or she has to meet. Further, as noted, even if there is an inherent jurisdiction to control vexatious litigation, that inherent jurisdiction is subordinate to the statutory jurisdiction. The former should not routinely be used to displace the latter. That being said, the Judicature Act does recognize that sometime the court must take the lead in controlling abuses. There is a public aspect to the use of court resources. As it was put in Olamide at paragraph 17 and 19, quote, "Courts are community property that exists to serve everyone, and have finite resources that cannot be squandered," unquote. Nevertheless, the court should initiate vexatious litigant proceedings with caution and should rarely assume the prosecution of such applications commenced by the parties. In summary, even though the court has the jurisdiction to institute vexatious litigant proceedings on its own motion, that should be the exception. The litigation should still be left in the hands of the litigants. If the litigants find behavior to be vexatious, but do not bring an application for a vexatious litigant order, they must not expect the court to take the initiative. The court should only act where the parties have for some reason failed to act, and the broader interests of the administration of justice are compromised. Was a vexatious litigant order justified in this case? With that background, the issues on which permission to appeal were granted in the case under appeal can be analyzed. The first issue is whether the case management judge erred in granting a comprehensive vexatious litigant order against the appellant. As noted, the application for a vexatious litigant order was brought by the parties and was not generated on the court's own motion. The application was specifically brought under the Judicature Act, and there was no justification for the court to mechanically divert it to be considered under the court's inherent jurisdiction. If a generalized vexatious litigant order was called for, there was no reason why the application could not have been analyzed in terms of the Judicature Act. There was no basis to suggest that the statutory regime was somehow inadequate, forcing the court to resort to its inherent jurisdiction. Further, the context is important, regardless of which procedure was used. As noted, the litigation arising from the appellant's bankruptcy has been going on for a number of years, and has been highly contentious. One of the registrars has been dealing with all applications at that level, and there have been case management judges in place for much of the time. It is not apparent that case management is an inadequate remedy for the problems identified. The application that led up to the order under appeal was brought before the case management judge by a number of investors who had lost money in the appellant's enterprise, described as the objecting creditors. The overall scope of the application, quote, was fixing the appropriate penalty for the findings of contempt, unquote, against the appellant that had previously been made and upheld on appeal. A wide variety of relief was claimed, including imprisonment for contempt. The application also claimed A. Judgment against the appellant in favor of each objecting creditor in specified amounts, with an order that the judgments would survive bankruptcy. B. An order restraining the appellant from disposing of property and requiring third parties to disclose property of the appellant. C. An order preventing the appellant from commencing or continuing any proceeding until all outstanding costs were paid. And D. A vexatious litigant order. In other words, the application for a vexatious litigant order was seen as being part of a remedy for contempt of court. The grounds for the application were largely centered on the previous findings of contempt. It was alleged that the appellant's contempt remained, quote, flagrant, repeated, continuous, and unrepentant, unquote, and that he had flouted orders for production, that he had, quote, mocked and disregarded the orders of the court, unquote, and had never apologized or attempted to purge his contempt. The application also listed some examples of the indicia of vexatious conduct commonly relied on by the court when invoking the inherent jurisdiction to impose vexatious litigant orders. For example, it listed some instances of collateral attack, escalating proceedings, bringing proceedings for improper purposes, persistently taking unsuccessful appeals from judicial decisions, and unsubstantiated allegations of conspiracy, fraud, and misconduct. These, however, were said to be, quote, evidence of his continuing intention to flout court orders, unquote. The tone of the application is that the appellant routinely disregarded court orders, the rules of court, and directions by the case management judge, and generally defended the bankruptcy litigation in a contemptuous way. The appellant points out that fresh attempts to purge his contempt are not a collateral attack on previous findings he had failed to do so, nor are they brought for improper purposes. He also notes that an application by his counsel to extend time to seek permission to appeal to the Supreme Court of Canada was incorrectly called a collateral attack, and that he had been successful on some appeals. Some of the objectionable material in his pleadings has been removed now that he has counsel. A vexatious litigant order prevents the litigant from continuing or commencing proceedings. A vexatious litigant order is not the obvious remedy for contempt. The fundamental question for the objecting creditors is, where did the money go? A vexatious litigant order is not going to generate the answer to that question. A vexatious litigant order cannot make a litigant discharge obligations under the rules of court or court orders. As noted, the purpose of a vexatious litigant order is to prevent a named litigant from commencing or continuing proceedings. It is somewhat anomalous to apply the concept to a defendant. The appellant has not been commencing or continuing proceedings. It is the objecting creditors who continue to press for further and better disclosure and sanctions for contempt. The appellant is primarily in a defensive mode, seeking to establish that he has in fact purged his contempt. He may be mounting his defense in an inappropriate way, but a vexatious litigant order precluding new proceedings appears out of context, and the order cannot reasonably prevent him from defending the allegations of contempt against him. Some of the allegations in the application did disclose vexatious conduct. For example, collateral attacks on decisions previously made by the registrar or the case management judge, and persistently taking unsuccessful appeals. But it appears that all of the appellant's conduct related to the bankruptcy proceedings. There is no indication that he commenced or continued proceedings with respect to any other topic. A case management order requiring that he receive permission before commencing any application or appeal within the bankruptcy proceeding was called for, but a general prohibition on him starting any action on any topic against any defendants was not justified. Further, there is no indication why a separate vexatious litigant order was needed, much less one of the breadth granted. The bankruptcy was already in case management. The registrar and case management judge had more than enough authority under Rule 4.14 to deal with any abuses within the bankruptcy litigation. It is unclear why the objecting creditors thought that a comprehensive vexatious litigant order was the proportionate response to the problem. Vexatious litigant orders should not become the default method of managing complex litigation. They are not the obvious response to defendants who are in default of their obligations under the rules or court orders. In summary, this was a case of complex litigation involving a difficult litigant which was already in case management. The issues should have been dealt with in case management. A blanket vexatious litigant order did not address the problem in a proportionate or effective way, and was not an effective or appropriate remedy for contempt. The case management judge should have granted a carefully crafted case management order, and possibly a litigation plan under Rule 4.5, instead of a boilerplate vexatious litigant order. Was a fair process utilized? The appellant argues that he did not receive a fair hearing before the vexatious litigant order was imposed. The application was brought on notice, the appellant was represented by counsel at the hearing, and he was given a full opportunity to address the issues. He argues that a two-stage process is required. First, the chamber's judge should decide if the respondent to the application is a vexatious litigant. Then, a second hearing should be held to determine the scope of the order. A respondent to a vexatious litigant application is entitled to a fair hearing, but that does not invariably require a bifurcation of the proceedings. The application gave notice that a vexatious litigant order was requested. The appellant was given a full opportunity to respond. Whether the order as granted was overbroad is discussed in the next section of these reasons. Was the vexatious litigant order overly broad? When a vexatious litigant order is granted pursuant to the court's inherent jurisdiction, a practice has developed of issuing lengthy, detailed, boilerplate vexatious litigant orders. Since vexatious litigant orders restrict access to the courts, they should be focused on the specific litigant, be proportionate to the issues, and be no wider than is reasonably necessary. In this case, a vexatious litigant order was not justified, but in any event, the order that was granted was overly broad. At a threshold level, the order granted was wider than the order requested in the application. Compare paragraphs 58 and 138 of the reasons. If nothing else, the appellant was not given full notice of the case he had to meet. The Judicature Act expressly gives the Court of Queen's Bench jurisdiction to make vexatious litigant orders that cover proceedings in the provincial court and the Court of Appeal. That jurisdiction can only be exercised pursuant to the Judicature Act. The inherent power of the court to control its own processes does not extend to controlling the processes of other courts. Since the Chamber's judge purported to grant this order under the inherent jurisdiction of the court, it was overbroad in its scope. There is no apparent explanation for a number of provisions in the order. For example, the appellant is directed to only describe himself by name, not by initials or pseudonym. There is no indication that he has ever done so. Likewise, there is no indication that the appellant has ever improperly provided legal advice to third parties, or abusively acted as an agent or Mackenzie friend. There is no indication that he has ever improperly attempted to swear a criminal information against any third party. These boilerplate provisions seem to have merely been carried forward from other orders where they may have been appropriate. The order requires the appellant to seek permission of the court before commencing or continuing any proceedings. It goes on to say that such permission can only be applied for if the appellant demonstrates he has paid in full all court-ordered cost awards against Neil Allen Lymer in the Alberta courts. Such a provision is unreasonable. Vexatious litigant orders are tolerable because they do not foreclose all access to the courts and merely perform a gatekeeping function. Insurmountable preconditions, however, effectively amount to a total barrier to court access. Assume that the vexatious litigant is injured in a motor vehicle accident, and the other driver is at fault. The vexatious litigant has a legitimate claim for damages. It would be an injustice to prevent that litigant from even applying to commence a personal injury action unless all prior cost awards and all other actions in Alberta are paid. Even though persistent failure to pay costs may be evidence of vexatious conduct, vexatious litigant orders are not intended to be a method of enforcing the payment of past financial obligations. Other than by operating as a total bar to court access, requiring payment of all outstanding past cost awards does nothing to prevent further vexatious litigation. It has been said that vexatious litigant awards should be prospective rather than punitive, yet this type of provision is routinely included in boilerplate vexatious litigant orders. If a vexatious litigant seeks permission to continue or commence legitimate fresh proceedings, it might well be appropriate to make the posting of security for costs a condition of those fresh proceedings. As observed in Goldstick Estates, quote, "A case management judge has a wide discretion to specify when and how applications will be brought, including the imposition of conditions precedent to any procedural step. Specifying that costs must be paid before further steps can be taken is not per se objectionable, but all of the relevant considerations must be carefully balanced. Controlling disproportionate and excessive litigation is important, but so too is maintaining access to justice. A beneficiary is entitled to have the conduct of an executrix examined by the court. It must be obvious that requiring the payment of costs as much as $340,000 is an insurmountable barrier to most litigants, even wealthy ones. The order under appeal effectively prohibits any further applications by the appellant." Unquote. Security for costs is primarily forward-looking and relates to proposed new procedures. Security for costs is not intended to be a method of enforcing past cost awards. The order also provides that the appellant cannot seek permission to commence fresh proceedings unless he is represented by a lawyer. Litigants have a right to represent themselves in court, and as previously noted, most self-represented litigants are unrepresented because they cannot afford a lawyer. Requiring the vexatious litigant to obtain a lawyer presents a financial barrier that may be insurmountable. The requirement that permission be requested through a lawyer also appears to be redundant. The very purpose of requiring a vexatious litigant to seek permission before commencing fresh proceedings is to allow the presiding judge to screen those proceedings. The presiding judge will want to ensure that the fresh proceedings disclose a known cause of action, are not a collateral attack on previous decisions, are not being commenced against parties who are unreasonably being brought into litigation, etc. Requiring the application for permission to be brought by a lawyer seems to be protection against the same things. Presumably, no responsible lawyer would seek permission to commence abusive proceedings. However, whatever advantage there might be from having the fresh litigation screened twice is disproportionate to the expense involved. It would generally be an error to impose such a condition at the permission stage, without precluding such a condition being imposed subsequently. In summary, the vexatious litigant order should not have been granted. What was called for was, at best, a more intensive case management process. However, even if the vexatious litigant order had been appropriate, the conditions imposed were unreasonable. The contempt sanction. The primary focus of the application brought by the objecting creditors was to set a sanction for the appellant's conduct, which was previously determined to be in contempt of court. The vexatious litigant order was proposed as a part of that sanction. The case management judge concluded that the appropriate sanction was 30 days imprisonment and a vexatious litigant order. The appellant argues that the sanction was imposed on him without a full and fair hearing, and that the penalty is excessive. He argues that a viva voce hearing was required. The core of the appellant's contempt was his failure to comply with various orders requiring that he disclose what had happened to the investor's money. He was ordered on several occasions to produce records from the corporations involved. He variously asserted that he had no records, he could not remember some of the facts, and he could not reconstruct the transactions. Then he produced some records, including 5 hard drives said to contain relevant records. His explanations were rejected by the courts. He was found to be in contempt, and those findings were upheld on appeal. The respondents correctly argue that the findings of contempt are res judicata, and the appellant is not entitled to question them at the sanction stage. The appellant agrees. However, the appellant argues that he has now purged his contempt, and that this is a significant mitigating factor in setting a sanction. The appellant was originally found to be in contempt by the registrar on November 6, 2014, and the jurisdiction of the registrar to do so was ultimately confirmed by this court on March 21, 2016. At the subsequent sanctions hearing in January 2015, the appellant was given an opportunity to purge his contempt, and on February 9, 2015 and August 22, 2016, he filed fresh affidavits of records in an attempt to do so. In May 2016, his creditors filed a second contempt application alleging fresh instances of contempt. In December 2015, the appellant applied for a declaration that he had purged his contempt. On February 14, 2017, the registrar concluded that he had not completely purged his contempt because his affidavits were qualified, evasive, and lacked detail. His appeal to a chambers judge was dismissed on May 26, 2017, and a further appeal was dismissed based on the overwhelming evidence that he had failed to purge his contempt. That set the stage for the present phase of the proceedings. On May 15, 2017, May 30, 2018, and June 21, 2018, the appellant filed further affidavits in another attempt to purchase contempt. The record does not indicate that his affidavit of May 15, 2017 was considered at the appeal on May 26, 2017, because it was anticipated that the registrar would review it at a future hearing. The appellant had not been cross-examined on any of these 3 affidavits. The sanctions hearing that generated this appeal occurred on April 20, 2018. The thrust of the appellant's argument was not an attack on the original findings of contempt, but an argument that his latest affidavits had purged that contempt. Despite not having cross-examined the appellant on his affidavits, the objecting creditors took the view that the affidavits still did not provide the required disclosure. The case management judge recognized that the record created a clear issue of credibility. For example, quote, "I reject this argument. It ultimately relies on Mr. Lymer's word. I make an unfavorable finding of fact in relation to Mr. Lymer's credibility. He is not an honest, credible person," unquote. And, quote, "I do not believe Mr. Lymer," unquote. And, quote, "These are 2 of many examples where Mr. Lymer is not a credible person," unquote. Although issues of credibility usually require an oral hearing, the case management judge concluded that one was not needed to resolve the credibility issue because he was not going to believe the appellant anyway. Quote, "Since I conclude there is no credible evidence that Mr. Lymer has successfully purged his contempt, or made good faith efforts to unsuccessfully purge his contempt, there is no need for a viva voce trial to evaluate to what degree Mr. Lymer has met those objectives," unquote. The case management judge essentially held that there was no credible evidence because he did not believe the appellant, and he did not believe him because there is no evidence to support his position. This entirely circular reasoning reflects palpable and overriding error. Civil contempt proceedings are quasi-criminal in nature, and they call for a high level of procedural fairness, especially where imprisonment is a real possibility. The principle was confirmed in Panesar and Palia. Quote, "It is trite law that a party facing a contempt finding should be given an opportunity to retain and instruct counsel, as well as an opportunity to provide an adequate excuse for failure to comply with court orders. The consequences of a contempt order are serious, so a contempt application merits a full and fair hearing with the opportunity to retain and instruct counsel and provide evidence." Unquote. While these comments were made with respect to findings of contempt, imposing sanctions for contempt raises similar issues. A person found in contempt, quote, "should be accorded the opportunity to offer an explanation or an apology before punishment is imposed." Unquote. A person being sanctioned for contempt is entitled to make full answer and defense, and if he wants to testify under oath in mitigation, he should rarely be denied the opportunity to do so. The appellant argues in the alternative that the 30 days of imprisonment imposed on him was unreasonably harsh. He argues that when the underlying contempt is a failure to produce documents, the contempt sanction is aimed more at securing the missing discovery than at punishment. Since the question of mitigation and sanction must be referred back for a new hearing, no further comment is needed on this argument at this time. The sanction must be set aside because of the failure to give the appellant a fair hearing, and the matter remitted back to the trial court for a proper hearing before a different judge. Summary. In summary, the following principles underlie vexatious litigant applications. A. The primary jurisdiction for awarding a vexatious litigant order is under the Judicature Act. Application should prima facie be initiated pursuant to the statute, whether by a litigant or by the court on its own motion. When proceedings are initiated pursuant to the statute, they should be adjudicated accordingly and should not routinely be diverted to any residual common law process. B. The provisions of the Judicature Act substantially occupy the field, and any residual inherent jurisdiction of the court is limited. Any application for a vexatious litigant order should first be assessed pursuant to the provisions of the Judicature Act. If the applicant cannot meet the test under that statute, the court may, in narrow circumstances, resort to its inherent jurisdiction. However, clear and compelling reasons must be shown for granting an order pursuant to the inherent jurisdiction when the applicant has failed to meet the test in the statute. C. In those circumstances where the court may rely on its residual inherent jurisdiction, vexatious litigant orders should not be granted that are in direct conflict with the statute. For example, such orders should not be granted unless the Attorney General has been given notice, and generally are not appropriate unless the conduct is persistent. D. Vexatious litigant applications should primarily be litigant-driven. While the court has a residual ability to trigger a vexatious litigant application on its own motion, the court should only initiate the process where the litigants have failed to do so after invitation and the overall interests of the administration of justice are engaged, or there is another justification for doing so. E. Applications for vexatious litigant orders are to be brought on notice to the respondent and the Attorney General, unless the conditions of Rule 6.4b are met, i.e. serving notice of the application might cause undue prejudice to the applicant. The respondent must be given a fair opportunity to be heard before the order is granted. In those rare cases where an ex parte or interim vexatious litigant order is appropriate, the order should be for a short, defined period of time and should be reviewable on short notice. F. Parties are entitled to self-represent, and the court should be sensitive to the challenges faced by self-represented litigants. Vexatious litigant orders should only be made when other procedural techniques have proven to be inadequate and the offensive conduct is persistent. G. Any restrictions imposed in a vexatious litigant order must be focused on the particular litigant, be proportional to the problematic conduct revealed by the record, and they should be incremental and adapt to the specific problem. Such orders should be no wider than is necessary and must not routinely limit access to court facilities or restrain resort to fee waivers, unless warranted by the facts of the particular case. Vexatious litigant orders are not a substitute for case management, and they are not a universal remedy for all procedural problems that may be encountered. H. Restrictions on a litigant's conduct should not, as a matter of course, include a requirement of legal representation or the precondition that all accumulated court costs be paid. In conclusion, the appeal is allowed. The vexatious litigant order should not have been granted in these circumstances, and in any event, the form of order granted was overbroad. The sanction for contempt cannot stand given the failure to afford the appellant a fair hearing. The question of sanction for contempt is referred back to the trial court for a fresh hearing before a different judge.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.